Hello friends, in the series on the income tax cases, today we will discuss a case which is based on section 245 and section 244A. Section 245 talks about set-off and withholding of refunds in certain cases, and nowadays it has been seen that the CPC is using section 245 to adjust the refund of the assessee against the outstanding demand of the assessee without following the mandate of section 245. The present issue before the Honorable Supreme Court was that if the refund of the assessee has been adjusted in violation of section 245, then whether the High Court has the power to grant the interest at a higher rate which is mentioned in section 244A, that is 6%. In the present case, the High Court has ordered to give the interest at 15%. So the question was that whether the High Court can do so. This issue has been taken up by Honorable Supreme Court in the case of Assistant Commissioner of Income Tax and others versus TSI Parks Hyderabad Private Limited. This case is reported in 477 ITR at page number 1. And the date of the judgment is 24th January 2025. In the present case, there was a refund of the assessee for the assessment year 1920, and the CPC adjusted the refund of the assessee for the assessment year 1920 for the outstanding demand for the assessment year 2008-9 and 17-18 in violation of section 245. Generally, the violation in these type of cases is that when the assessee files the appeal before the CIT appeal, then he has to deposit 20% of the outstanding demand. But it has been seen that the CPC is always adjusting the refund of the assessee in more than 20% of the outstanding demand of the assessee. And if any opportunity is being given to the assessee to reply, even then, whatever the reply assessee submit, that is not taken care of by the CPC. It is very harsh for the assessee. But in the present case, the assessee can afford to go to the High Court in a writ petition, and his writ petition was allowed, in which a good favor was done and a very welcome judgment has come from the High Court by awarding the interest of 15% on the refund which was wrongly adjusted by the CPC under section 245. And in this case, the rate of interest was awarded at 15%. The department contested this matter before the Honorable Supreme Court, and the main contention of the revenue was that the rate of interest mentioned in section 244A is 6%. So the High Court was in error to give the interest at the rate of 15%. The High Court allowed the appeal of the revenue, and in the meantime, when the order was stayed of the High Court, the interest was given by the revenue to the assessee, and this excess interest was coming 36 lakh, which was the difference of 15% and 6%. So the Supreme Court passed an order that the High Court was not right in giving the interest above 6% because the rate of interest mentioned in section 244A is 6%, and hence directed the assessee to give that money which was given in the form of excess interest, that is the difference between 5% and 6%, to the revenue. Friends, in this case, it is the message is that the revenue has not to give the interest above than 6%, but the pain lies with the assessee that whenever these type of illegal adjustments are done under section 245, even the small assessee cannot afford to go to the writ courts, and his refunds are illegally adjusted. And when some assessee who can afford the litigation, even in that case also he can just ask his money back with interest at the rate of 6%. So there should be some mechanism and there should be some law on the statute that whenever the refunds are illegally adjusted or not adjusted as per the mandate of the law, then in that case the rate of interest should not be normal 6%, but it should be higher, so that the assessee can be at least given some relief in favor of some higher interest, because any act which is done beyond the law is not entertainable by the courts also. But in this case, with due respect to the Supreme Court ordered to refund the excess interest which was given to the assessee, and ordered the assessee to give 36.61 excess interest to the revenue. At the end of this video, once again I am repeating the name of the case. The name of the case is Assistant Commissioner of Income Tax and Others versus TSI Business Parks Hyderabad Private Limited, and this case is reported in 477 ITR at page number 1, and the date of the judgment is 24th January 2025. Thank you, friends.